Welcome to LLBM News Channel. I'm your host, Lauren Spencer.
And I'm Luke McCartney. On tonight's program, we'll be discussing the development of freedom of religion establishment in the history of America with court cases that affect them.
We will also be joined by Matt Zhang and Ben Oldham, who will give us an in-depth overview to court cases that set the precedent for current court cases to come. Freedom of religion, by definition, is the right to practice whatever religion one chooses to. The freedom of religion establishment is protected under the Establishment Clause and Free Exercise Clause, which is stated in the First Amendment, which states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This means that cases in this area pertain to citizens claiming to having certain religions imposed or forced upon them. This is very important to us because we need to know our religious rights and how they are protected under the U.S. Constitution. The current precedents we use today stem from both the 1962 Engel v. Vitale Supreme Court case and the 1971 Lemon v. Kurtzman case. The Establishment Clause in the First Amendment first set the precedent for these types of cases. In the 1962 case, Engel v. Vitale, it first set the precedent for the separation of church and state, which prevents the government from officially recognizing or favoring any religion. In the 1971 Lemon v. Kurtzman case, the Lemon three-point test was set as a precedent. The Lemon three-point test says that for a law to be considered constitutional under the Establishment Clause of the First Amendment, the law must 1. Have a legitimate secular purpose, 2. It must not have the primary effect of either advancing or inhibiting religion, and thirdly, it must not result in an excessive entanglement of government and religion. And now we will hear from English reporter Ben Oldham.
Thanks, Lauren. I'm here outside the courtroom to discuss the 1962 Engel v. Vitale court case, which would become the basis for several subsequent decisions limiting government-directed prayer in schools. The case was brought forward by a group of families of public school students in New York who complained that prayer written by the state board contradicted their beliefs. A state law required all public schools to start the day with the Pledge of Allegiance, followed by a non-denominational prayer. The law did allow students to abstain from the prayer if they chose to. The plaintiffs argued that starting the school day with such a prayer violated the Establishment Clause of the First Amendment in the U.S. Constitution. The ultimate question? Whether school-sponsored non-denominational prayer in public schools violated the Establishment Clause. The justices ruled 8-1 that the school-sponsored prayer did indeed violate the First Amendment. This case is so significant as it established the precedent of the separation of church and state. This case furthered this precedent not only in schools, but also how the Establishment Clause will be interpreted in the Supreme Court. Engel v. Vitale helped establish what exactly the Establishment Clause outlined and what limitations it placed on the national government as well as the US citizens. I'm joined by Supreme Court Justice Duke, who is going to tell us about why himself and the other justices ruled the way they did. So, Justice, why did the court rule this way?
Well, the school's prayer is a religious activity. Prescribing such an activity to school children violates the Establishment Clause. The program was created to promote religious belief, which in turn is unconstitutional.
Thank you, Justice. Now over to Matt inside the courthouse.
Lemon v. Cosmo was a court case argued before the Supreme Court of the United States to discuss a very important issue. Does the state funding for non-public, non-secular school a violation of the Establishment Clause of the First Amendment? The cause of this discussion is because Pennsylvania and Rhode Island both have a statute that provides funding for the secular material in non-public school to ensure the quality of the secular part of the school's education. Court decision for both Pennsylvania and Rhode Island statutes sided with the accused and declared that the state statutes are unconstitutional, violating the Establishment Clause of the First Amendment, and a 8-0 and 8-1 majority for each respectively. And the reason behind this decision is the amount of oversight of teachers and curricula required to ensure that there is no unnecessary injections of religious into secular topic will require the government to become excessively involved in the nuances of religious education. And here I am joined by the Supreme Court Justice Florin, who will give us some comments on the court case decision. So Justice, what is your reasoning behind such decision?
Well, the danger was not only that religion would infiltrate the government, but also that the government would push secularization onto religious creeds. So we are stopping the funding to protect the identity of the religious groups and their ideas.
Thank you for your time, Justice Florin. And now we're back to studio.
Well, it looks like we lost him there, but now we have heard from Matt and Ben describing the precedents for the Establishment Court cases. This precedent continues to affect court cases currently and even expands our limits on rights. And here are some examples of these court cases. In 1973, there was a United States Supreme Court case, Abington School District versus Shemp. That was started by an appeal from Edward Shemp saying that Bible readings and prayers cannot be led by the school and force students to partake in them. The court ruled in favor with an 8-1 vote in favor of Shemp. The reason for this vote can be traced back to the limit test that was mentioned earlier. The schools failed the first test with having religious information that is an enhancement for secular education in the curriculum. Similarly, in 1980, there was a Stone versus Graham case in the Supreme Court, which was over the posting of the Ten Commandments in a school classroom. The court also ruled against the school system, saying that the school could not post religious propaganda that did not pertain to school lessons. The court ruled that this was a violation of the Establishment Clause. In 2005, the Kitzmiller v. Dover Area School District case, the challenger brought testing to a public school district policy that required teaching of intelligent design. Dover Area School District presented intelligent design as an alternative to evolution in biology. Plaintiffs successfully argued that teaching intelligent design is a form of creationism, and that the policy violated the Establishment Clause of the First Amendment. Another 2005 court case, Town of Greece versus Galloway, the argument between American United versus the separation of church and state and the Town of Greece starts from the fact that Greece permitted chaplains to volunteer before each legislative session with a prayer. The court took the case and sided with the Town of Greece in the ruling. The justice thinks the Town of Greece are not discriminating against minority religions, but rather just following a tradition. Finally, we look at the Arizona Christian School Tuition Organization versus Wynn case in 2011. Arizona taxpayers challenged the constitutionality of Arizona's tuition tax credit. They alleged that the tax credit violated the Establishment Clause of the First Amendment because it funneled money to private religious schools. The law gives tax contributions to school tuition organizations when they use contributions to provide scholarships for students attending private schools. The Supreme Court overturned the lower court's decision that the taxpayers should not pay for this tax. The majority held that the challengers lacked standing under Article 3. State residents do not have the right to challenge state tax credit simply because they pay taxes. The court rejected the idea that continuing legal or cognizable interest in ensuring that those funds are not used by the government in a way that violates the Constitution. Any harm claimed by these taxpayers simply because they are taxpayers would be pure speculation.
All